If there is intent to deny access, you need to prepare a notice of intent to exercise visitation letter stating the specific dates as laid out in your order. Add to this a notice of intent to exercise parental rights in the same legal format as your other court papers. Sign both and make 6 copies. Mail the originals certified mail and a set with just delivery confirmation, which costs 75 cents plus postage. If she rejects the certified letter, she will still receive the letter with the delivery confirmation. Remember, these are 2 different types of mail. To get a confirmation of delivery printout, go to the USPS website and enter in the number from your receipt, as noted in this example. If the certified letter or the certified letter confirmation of delivery card with her signature on it comes back, attach either to a copy of the Notice of Intent to Exercise Visitation letter and a copy of the Notice of Intent to Exercise Parental Rights, plus the printout of the delivery confirmation from the USPS. Do not open the letter if it is returned. Take these documents to the county courthouse. Have the clerk of the court notarize and place them in your case file. It is very important that you repeat this process every time you are to exercise your visitation until either she obeys the orders or you go to court. Before any hearing, a judge reviews the case file so that he or she will see your efforts to resolve this issue without involving the court. File the remaining copies for future use. If the other parent continues to deny you access, you need to decide if you want to use an attorney or go propria persona, pro per, in taking an enforcement action to the courts. As noted before, the federal government has made funding available to the states for developing model programs to ensure that children will be able to have the continuing care and emotional support of both parents. Check with your local child support enforcement agency and or the clerk of the court to see what resources are available to you and to find out about laws that address custody and visitation. There are also document preparation services that can be of help. A doc prep service cannot give you advice, so you need to know what you want when you arrive. If you wish to use an attorney, you need to take the time to interview attorneys before picking the one to work with. Prepare a chronological statement expressing a history from the time you met the other parent until now. A common complaint in dealing with this action in the courts is bias on the part of the judge. For the most part, the issue is not as much bias as a lack of preparedness, including using the right attorney. However, to address any potential bias, it is best to use court watchers, which are persons who are there to witness the proceedings and not to testify. They can be a friend or relative, though the best choice would be some young man in the Boy Scouts who is working on his government badge to become an Eagle Scout. Follow this link to find a sample of the form for use in this regard. If you decide to represent yourself in court, check with your clerk of the court for forms for filing for enforcement action. If they do not have one specific for visitation, the ones for child support will work as a template. You need to produce a notice of exercise of parental rights. You file this with the clerk of the court and have the judge sign it. Serve or have it served on the other parent, depending on the requirements of your state. In Kansas, it can be sent by certified mail. Produce a notice of the court of denial of exercise of parental rights and motion to show cause for contempt of court of denial of visitation for filing with the clerk of the court. Note, this is where it can get complicated on what choices you wish to make. If held in contempt of court, this is considered a change of circumstances, which are grounds for a change of custody arrangements. You or your attorney need to have a motion for change of custody ready to hand the judge in the event of this ruling.